Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Charged offense of Class C felony theft. His punishment will be 3 years TDOC, range 1, Tennessee Department of Correction. He will owe $50,000 in restitution to the victim, Jonathan Boggs, and he'll be responsible for the court costs in this matter. He's a standard range 1 sentence here. He has pretrial jail credits from September 27 to 2024.
All right. Is this possibility, I don't know what his immigration status is, but is this likely to affect his immigration status? All right.
I've explained the implications, the impact that this conviction would have.
You have a plea agreement sheet then?
Yes, sir.
Mr. Supervici needs to raise his right hand and be placed under oath. Raise your right hand and be placed under oath.
Yes.
All right. State your full name for the record.
Supervici Vasily.
Mr. Supervici is charged here with theft. Has he seen or been shown a copy of those charges? You can put your hand down now. Is his answer yes, he has seen them?
Yes.
Does he fully understand what he is charged with?
Yes, sir.
Does he understand that he has a right to plead not guilty and have a speedy and public trial by jury?
Yes, yes, sir.
Does he understand he would have the right to have a lawyer and to have one appointed for him if necessary?
Yes.
Does he understand at trial he would be presumed to be innocent? Until such time, if ever the state proved his guilt beyond a reasonable doubt. To the satisfaction of all 12 jurors, and their verdict would have to be unanimous. Does he understand that? Does he also understand that if he went to trial, he and his lawyer could confront all witnesses the state called? And he could cross-examine them, and he could bring in his own witnesses by using a subpoena. Does he understand that if he went to trial, he would be presumed to be innocent? He would not have to testify or prove anything at trial, and no inference of guilt would arise because he did not testify at his trial. Does he understand that? Does he understand that if he went to trial and was found guilty, he could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help him? He needs to answer verbally, yes or no.
Yes.
Does he understand that by entering a plea of no contest, he is waiving his right to a trial and to an appeal? Is his decision to plead guilty, to plead no contest today voluntary?
Yes, sir.
Also, does he understand that this is going to result in a felony conviction that will be on his record in the future to make more severe the punishment he will receive if he's ever again convicted of a crime. Does he understand that this will also affect his immigration status and that I am advised that there is a hold on him for the immigration authorities? Does he understand everything I've explained thus far?
Yes, sir.
And I think I asked, but is his decision to plead no contest voluntary?
Yes.
Does he understand I cannot accept his plea unless I'm satisfied there are facts to support it? Then he needs to listen as the state tells me what their evidence would be at trial.
Your Honor, if this case had gone to trial, the state would have presented evidence to show that on June 14th of 2024, Mr. Boggs, who lives in Dickson County, reached out to a website that was advertising a 1977 Ford Bronco for sale. Mr. Boggs spoke to a person purporting to be the sales manager. He also exchanged multiple emails and decided to purchase the vehicle. On June 14th of 2024, Mr. Boggs did wire $50,000 to this auto company, Smith Auto Body and Sales. At that point in time, the manager, or who he purported to be the manager, stated that the vehicle was going to be shipped and delivered on June 18th. The vehicle was never delivered, and all communication ceased. This case involved a lot of investigation from Detective Clark Evans. He served multiple subpoenas and search warrants to determine the owner of the account that this money was wired to. There were ATM withdrawals from this account. The ATM images showed what was ultimately determined to be Mr. Supravici. Homeland Security assisted in facial recognition, as well as Customs and Border Patrol, and determined the match was Mr. Supravici. There are other states that want Mr. Supravici for similar instances of theft. And Mr. Supravici ultimately was discovered with numerous false identifications, including licenses and passports. That would be the evidence of the state.
Do you understand, Mr. Supravici, that that is the state's evidence if this case went to trial?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir. Thank you.
Do you believe he has done a good job of representing you competently?
Yes, sir. Thank you.
Mr. Talbot, do you know of any reason he should not enter this plea? Anything further from the state? Then Vasily Supravici and docket number 2024 CR 200. Upon your plea of no contest to count 1, I find you guilty, sentence you to 3 years, Tennessee Department of Corrections as a range 1 offender. Order that you pay restitution of $50,000 to the victim, in this case, Jonathan Boggs, and you pay court costs. That is the judgment of the court.
Page 38 of your Honor's docket, at the bottom of the page, that'll be Danny Ray Tummins. Mr. Tummins will, subject to the court's approval, enter a no contest plea to the amended count of theft, a Class E felony. His punishment on this will be 3 years TDOC range 2, suspended to probation. He'll owe restitution to the victim in the amount of $4,640, which must be paid in equal monthly installments. There will be zero tolerance as to the monthly payments. He also must report to probation in person at least monthly, with a minimum of 1 drug screen per month, and zero tolerance regarding the any positive drug screen violations. He's responsible for court costs, and he has pretrial jail credits listed on this plea sheet, which he has already signed.
Tummins, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
Danny Ray Tummins
Mr.
II.
Tummins, you are here today charged with theft of property, and it's being amended to a Class E felony theft. But have you seen or been shown a copy of those charges? Talked them over with your lawyer, and you and Mr. Talbot discussed the range of punishments you're facing, along with any possible defenses you might have.
Yes, sir, I have.
Well, it's indicated you want to enter a plea of no contest or nolo contendere. All that means is you know what the state's evidence is. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And they'll tell me what their evidence will be at trial, and I'll use that to support a finding of guilt in your case.
Yes, sir.
You understand that?
Yes, sir.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury.
Yes, sir, I do.
You understand if we had that trial that you would have the right to have a lawyer and to have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir, I do.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, or no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
But you understand that's going to result in a conviction that will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir, I do.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest according to this agreement and waive your right to a trial?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand that I can't accept your plea unless I'm satisfied there is a basis for it and that you are in fact guilty.
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if you went to trial.
Your Honor, if this was to have gone to trial, the state would have put on evidence to show that on January the 19th of 2022, here in Dickson County, that Miss Lori Whitaker met with Danny Tummins at her home and had an agreement for him to install a pool at her residence. They made an agreement for her to pay half of the amount of the pool up front so that he could purchase materials for the job. She sent him on that date $4,660 by way of Venmo. approximately by May, Mr. Tummins had not delivered any material nor done any work. At that point in time, she requested that he return the money to her. He did not do that. And then once a police report was filed, officers, the detective, Tony Campbell, also reached out to Mr. Tummins to make sure that he knew that he needed to return the money, and he stated he would, but Mr. Tummins never returned the money.
All right, Mr. Tummins, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, sir, I do.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
And you believe that Mr. Talbot's done a good job of representing you competently?
Yes, sir.
Mr. Talbot, you know of any reason he should not enter this plea?
No, sir.
Anything further from the state? Then docket number 2022 CR 317, Mr. Tummins, upon your plea of no contest to the amended charge of theft of Class E felony, I find you guilty, sentence you to 3 years, Tennessee Department of Corrections, as a range 2 offender that will be suspended to probation. You'll be ordered to pay restitution to the victim of $4,690 in equal monthly installments. Zero tolerance as to the monthly payment. You miss one payment, that violates your probation. You're also to report to a probation in person at least monthly, a minimum of at least one drug screen per month with a zero tolerance regarding a positive drug screen, meaning one positive drug screen will violate your probation and send you to prison. You're ordered to pay the court costs. He needs to see the probation department before he leaves.